Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Suppose you were invited to a Senate hearing. You have a choice. You either attend or you don't show up. But if you do, what happens if you don't want to answer the questions? Can you be cited in contempt and ordered arrested by the Senate? Hi, I'm Attorney Mike Davadio, Supreme Court Chief Communications Officer. It's the 18th of October 2024, and today we talk about the case of Lincoln Ong versus the Senate of the Philippines, decided on March 28, 2023. It's an en banc decision penned by Supreme Court Associate Justice Henry Jean-Paul B. Inting. And joining us to talk about this case, the Attorney Ana Bartolome Llerenas and Attorney Brett Vernice Reduan from the Office of Associate Justice Inting. Hi, Attorney Ana, Attorney Brett. Thanks for joining us. Welcome to the Supreme Court Podcast.
Hi, Mike. Good afternoon.
Hi, Attorney Mike. Thanks for having us.
All right, so this case was quite controversial a few years ago. This procurement issue involving a company called Farmally. Remind us what happened in this case.
All right. So, the Senate Blue Ribbon Committee organized a number of increase in aid of legislation in connection with the expenditures of the Department of Health, or DOH, as regards the procurement of personal protective equipment, or PPEs, for COVID-19 at that time. So, the DOH awarded several contracts to Farmally Pharmaceuticals. It was a corporation that was registered with the SEC only sometime in 2019. The government contract that was awarded to it was in 2020. So there was some considerable lack of track record at that time with regard to Farmally. That's why the Senate Blue Ribbon Committee organized the inquiry in aid of legislation pertaining to the expenditures with regard to those contracts. Lincoln Ong was a director and shareholder of Farmally Pharmaceuticals. That's why he was asked to appear before the Senate with regard to that contract. Michael Yang at that time was the former economic advisor of then President Rodrigo Duterte, and allegedly he had some participation in the Farmally contract in connection with several Chinese suppliers of Farmally.
Mm-hmm. So that's why they were summoned to the Senate, to shed light on their participation in the Farmally deals, right? So, but why were they cited in contempt? What happened during the Senate hearing?
So, for this one, it's important to note that there were two contempt orders actually. So, the Senate Blue Ribbon Committee first cited Ong and Yang in contempt for their failure to appear despite notice for the legislative hearings held on August 27 and September 7, 2021. This is the first contempt order. For the second contempt order, this was issued by the Senate Blue Ribbon Committee during the legislative hearing on September 10, 2021, wherein both Ong and Yang were present via video conference because at the time it was still the COVID pandemic and everyone only appeared via video conference. So this time, they were cited in contempt for having testified falsely and evasively during the legislative hearing. Like, on the spot, they were said to have testified falsely and evasively, and the committee cited them in contempt right away.
Mm-hmm. Were they actually arrested as a result of the contempt orders?
Lincoln Ong was eventually arrested. He was cited in contempt in September 10. He was eventually arrested in September 21. Mm-hmm. Michael Yang was never arrested. He was cited in contempt, but he was able to evade arrest.
Mm-hmm. Attorney Pretz mentioned that Yang was never arrested. He evaded arrest. And this is, of course, because the Senate hearings were via video conference. So he was never really in the Senate premises to begin with. But this is also the reason why the Senate Blue Ribbon Committee requested that a lookout bulletin be issued against Yang because he was nowhere to be found and he could not be arrested. So, and he eventually failed to appear in the subsequent hearings. Mm-hmm. So that's why the lookout bulletin is actually one of the things that Yang is also questioning in the petition that he filed before the court.
So petitions were filed by both Ong and Yang against the contempt orders and arrest orders, and also the lookout bulletin order against Yang.
Yes.
So what were the grounds that they raised against the contempt and arrest orders by the Senate?
Lincoln Ong argued on 2 points. First, that the rules of the Senate with regard to citing a person in contempt for falsely testifying or evasively testifying was vague. His second point was that the requirement under Article 6, Section 21 of the Constitution for the rights of persons appearing before the Senate to be respected, according to him, his right to due process was not observed by the Senate when it cited him in contempt. Yang argued similarly. Essentially, he said that he was deprived of his right to counsel, that his rights as a person appearing before the court were not observed by the Senate, that the Senate was requiring information from him which were unrelated to the alleged inquiry in aid of legislation, and finally, that the lookout bulletin violated this right.
But before we go to how the Supreme Court decided the petitions filed by Ong and Yang, let's give our listeners a bit of a background about inquiries in aid of legislation. We hear this all the time. The Senate or Congress or the House of Representatives calls for a hearing on a hot topic of the day, for example, and they would always say, this is an inquiry in aid of legislation. What does that actually mean? Where do they draw the power from that? And how is this related to their contempt?
Inquiry in aid of legislation, it relates to the power of the Congress to pass laws, to enact laws for public purposes. It's a policy determination procedure on the part of the Senate and the House of Representatives to ascertain what law will be appropriate to enact for public safety, for any public purpose. Particularly with regard to this case, if you recall, there were a number of bayanihan laws which were passed by Congress during the COVID-19 pandemic, and they organized this Blue Ribbon Committee hearing, particularly to ascertain how to improve on those laws. Because if you recall, DOH was particularly authorized to procure PPEs, one of the bayanihan laws that were passed. So they were trying to improve, at least according to the Senate during the privileged speech of one of the senators at that time, they were trying to improve on those laws that they were enacting in connection with the COVID-19 pandemic.
So sure, they were trying to interview people, to ask people about how certain laws were implemented, if there are loopholes in the law, so that they can improve on the law. That's really the goal of increasing aid of legislation, right? And this has basis in the Constitution?
Yes. So the power of legislature to conduct inquiries in aid of legislation is based on Section 21, Article 6 of the 1987 Constitution. And this power to conduct such inquiries necessarily includes the power of contempt. Okay, as the court ruled in the decision, the legislature's power of contempt is inherent and arises by implication. This means that the power of legislative contempt is essential as it gives the Senate or the House of Representatives the power to compel the availability of information necessary in shaping legislation.
So, whereas the legal basis for inquiries in aid of legislation is in the Constitution, the basis for the Senate or the House of Representatives holding someone in contempt is actually by implication. It's not necessarily written in the law.
Yes.
But for you to be able to enforce your power to conduct an inquiry in aid of legislation, you need to be able to cite people in contempt so that they can attend the hearing.
Yes, and you can compel them to answer questions in relation to the inquiry. So if Senate or the House of Representatives are not granted this power by implication, then they wouldn't really be able to fulfill their duty in the first place, because the person, the witness, can just not attend the hearings in the first place, and the Senate or the House of Representatives would have no recourse against them if there's no power of legislative contempt.
And this legislative contempt powers, which the implication, does it also extend to ordering the arrest of anyone who refuses to heed a summon to appear before the Senate?
Yes, but just to, by way of background, yes, the power of contempt is not written in our Constitution. But for a number of cases, as way back in 1950s, the Arnold case, the court already discussed the basis for the contempt powers of the legislature. It has some history in the American system. So we go back even to the point of the common law system of the UK, because the point is, even though it's not written in the Constitution, it's a mode of self-preservation on the part of the legislature to be able to compel the attendance of witnesses, compel the production of documents, even private papers, to cite people in contempt so that it may collect the information that is necessary for it to enact the laws which will help the nation. Why? Because in a number of cases, the court would always say the senators, the congresspersons, they are not always in possession of the information that is necessary for them to enact the appropriate laws, which is why they need resource persons. And these resource persons, they are the ones who are summoned during inquiries in aid of legislation. If they cannot summon these resource persons because they have no power of contempt, we can stop Congress from performing their functions, which is why they have to inherently, and by court decisions, we have long recognized the power of the legislature to issue contempt orders, to issue subpoenas, compel testimonies, and the production of documents. The question, particularly with regard to family, is, does this power extend to the power of the Congress or the Senate to order the arrest of persons who are cited in contempt? The court said yes. Why? Because if they cite a person in contempt, if this person is not within their premises, how can they enforce the contempt order? Other than to order also the arrest of that person. And we have to recall, when this contempt order was issued, at least with Lincoln Ong, during the September 10 hearing, and Michael Yang, same hearing, September 10, they were both attending by video conference. So how can the Congress, how can the Senate obtain jurisdiction over them if they're not really appearing in the Senate at that time because of the COVID-19 pandemic? That's why an order of arrest was included in enforcing that contempt order. But we have to take it in that context only, at least without looking at the validity of the contempt order. They were already cited in contempt before the arrest was issued. The Senate first found that there was contumacious conduct, and then it ordered the arrest of Lincoln Ong and Michael Yang.
So it's clear that in order to enforce their power to conduct inquiries in aid of legislation, they have contempt powers. They can also order the arrest of an individual. But are there limits to these powers of the Senate and the House of Representatives so as not to result to abuse?
Yes, so the court discussed categorically in the decision that the exercise of the power of legislative investigation is subject to 3 limitations under the Constitution. So the first one is that the inquiry must be in aid of legislation, as we talked about earlier. The second one is that the inquiry must be conducted in accordance with the legislative body's duly published rules of procedure. This means that the Senate rules of procedure and the House of Representatives rules of procedure, which are not the same, because each body is allowed to adopt their own rules of procedure. So it would depend on which body is conducting the legislative inquiry, so that we know which rules to apply during the proceedings. And then the third one is that the rights of the person, specifically their rights under the Bill of Rights, must be respected by the legislative body during the proceedings in question.
So in the case of Ong and Yang, will these limits actually follow?
Unfortunately, no.
In the case, the court found that only the first 2 limitations were followed. As I mentioned earlier, the subject legislative hearings were conducted in aid of legislation, specifically to determine if the funds appropriated for the COVID-19 pandemic were properly utilized. In addition, the legislative inquiry was conducted in accordance with the Senate rules, particularly with 13 senators present. The attendance was more than the quorum requirement for the legislative hearing on September 10, 2021, per Section 4 of the Senate Rules of Procedure. As for the third limitation, Attorney Pretz will discuss this with us.
Okay, so for the third limitation with respect to respecting the rights of persons appearing during the inquiries in aid of legislation, that one was not observed. The right involved here would be due process.
So how were they deprived of their rights to due process?
Before they were cited in contempt, they were not given the opportunity to explain their side. That was the discussion in the ponencia. And it is obvious from the facts of the case. When they attended the hearing in September 10, it was in the same hearing when they were cited in contempt. There was no prior show cause that was issued by the Senate for Ong and Yang to explain why they should not be cited in contempt for allegedly, falsely, or evasively testifying before the Senate. there was just a summary finding by the Senate that they were falsely and evasively testifying during the proceedings.
So what does this mean? I mean, if the senators find that you're not answering their questions, they need to tell you that you have to explain why you're not answering our questions for you to be given the right to be processed. Is that the implication of this?
Okay. So, Attorney Mike, if you notice from the discussion at the ponencia, what the court said was even inconsistent statements by the resource persons were taken as false or evasive. So, on the part of the Senate, if it found that there were inconsistencies or if it found that they were evading the questions, then based on the ponencia, it should have first directed Ong and Yang to explain why they were answering in such a manner, or essentially to explain their side. Are they testifying falsely or are they testifying evasively?
So does this mean, Attorney Anna, that the person is being cited in contempt should first be informed which part of his or her statements are actually false?
Yes, Attorney Mike. Actually, that's one of the important points of the decision, that the resource person that was supposed to have testified falsely or evasively should be informed by the legislative body of which portion of his or her testimony was deemed to be false or evasive. Otherwise, he or she would not be able to fully explain why he or she should not be cited in contempt, because he or she is not even aware of which portion of the testimony was found to be untrue or evasive by the body.
So let's go to the specifics. How exactly did they supposedly, quote unquote, testify falsely or evasively according to this?
All right. So on the part of Lincoln Ong, the Senate determined that he was falsely and evasively testifying with regard to, first, the participation of Yang in the contracts of Pharmaly. Second, the funds that Pharmaly used to pay for the suppliers, considering that it only had a paid-up capital of around 625,000 pesos. Third, the pricing or costing that they used is as regards the PPEs that they purchased from the suppliers, because allegedly there was overpricing involved. On the part of Yang, the Senate determined that he was falsely and evasively testifying with regard to his knowledge of Pharmaly, because initially he said that he only knew of Pharmaly through news or public information. But then, upon further questioning, he said that he knew certain personalities in Pharmaly and he introduced them to several suppliers, and that he acted as guarantee or a guarantor in paying these suppliers.
Thanks, Attorney Pretz. That's on the part of the Senate. But Attorney Anna, did the court side with the Senate with respect to their determination of whether Ong and Yang testified falsely or evasively?
So, Attorney Mike, in the decision, the court disagreed with the Senate's position on this matter. It discussed that Ong had explained how Pharmaly was able to pay the initial order 54 million, stating that they had other funds sourced from the savings of the incorporators, and they also borrowed money from friends. This is aside from the paid-up capital of 625,000. That Pharmaly only had 625,000 pesos as paid-up capital for the beginning of the year 2020. The court also noted that Ong also manifested his willingness to cooperate with the Anti-Money Laundering Council to explain exactly where these funds came from. Essentially, the court said that Ong had manifested his intention to cooperate in the process. So, in short, why did the Senate cite him in contempt despite his willingness to cooperate and offer information? In addition to this, the court also stated that Ong's hesitancy in giving direct answers does not conclusively establish that he was being evasive. It explained that the totality of Ong's responses evinces that he was mindful simply of his right against self-incrimination.
So when he invokes his right against self-incrimination, it doesn't necessarily mean he's guilty or he's lying.
Yes.
That's a takeaway. So we've been discussing this whole concept of testifying falsely or evasively. This phrase actually comes from Section 18 of the Senate Rules on Inquiries, which incidentally they're also questioning as allegedly unconstitutional. So did the court make a finding as to the validity of this particular section?
Yes, Lincoln Ong particularly raised the argument that that provision of the Senate rules was void for being vague. But the void for vagueness doctrine, it only applies if a person of common intelligence will not be able to understand in any circumstance that phrase. In the ponencia, it was explained, and rightly so, that any person can understand what that phrase means, falsely or evasively testifying. The court even defined what false or evasive testimony means. False meaning it's untrue, evasive meaning you're not providing direct answers. That would be tantamount to a refusal to answer the question propounded upon the resource person. And according to the court, based on common intelligence, ordinary intelligence, any person would be able to understand the phrase, therefore, it's not unconstitutional for being vague.
So it's not unconstitutional. The rule is perfectly valid. It's just that in this particular case, the factual circumstances didn't allow for this finding by the Senate to be upheld by the court.
Yes.
So what about the argument of Mr. Yang that the testimony and the documents that were required of him would violate his right to privacy? Can they invoke that in a Senate hearing?
But with regard to this particular case, the court noted that the information that were being requested from Yang pertained to his business and financial interests, which had a relation to the public policy determination in issue, which pertains to the expenditures of DOH for the PPEs and the alleged anomalous transactions involving certain personalities, which essentially enrich people, unduly enrich people. So there is a connection between the financial interest of Yang and the government contract involved in this case. So the court said the right to privacy, yes, a person has a right to privacy, but it is not absolute. If the legislature finds it necessary to require a person to disclose those information because it bears relation to the inquiry in aid of legislation, then the right it's not inviolable in that case.
So the right of the Senate and the House of Representatives to find out the truth about a particular transaction will outweigh the privacy rights of a specific resource person.
Yes, but again, it has to be decided within this context. But there was a compelling interest. That was what the court said. That there was a compelling interest to require the disclosure of that information because it has a relation to legislation.
Thanks, Attorney Brett. Maybe just by way of closing this discussion, Attorney Anna, Attorney Brett, what's the biggest takeaway from this case? Attorney Anna.
So, Attorney Mike, I think the biggest takeaway from this case is that the exercise of the power of legislative contempt must not violate the constitutional rights of the resource persons appearing before the legislative body, most especially the right to due process of law. So, this means that the legislative witness must be accorded the opportunity to be heard, which is the chance to explain why the questioned portion of his or her testimony is not false or evasive before he or she is cited in contempt.
Thanks, Attorney Anna. And the last word goes to you, Attorney Brett.
Yeah. So on my part, I would think that this case presents an illustration of how the court has to strike a balance between the rights of individuals and the right of the state to ensure that there is proper functioning of the legislature. On one hand, the legislature has an interest in maintaining its power to enact laws and its authority to conduct inquiries in aid of legislation. On the other hand, the resource persons have rights as well, like the right to privacy of Yang, the right to due process. So, at the end of the day, the court had to strike a balance here on how to ensure that both rights are maintained.
Very interesting discussion, and big thanks to you, Attorney Anna, Attorney Pretz, for joining us today. We hope to have you next time.
Thanks, Attorney Mike, for having us.
Thanks, Mike.
Right, so I hope you enjoyed that one. And if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for Lincoln Ong versus the Senate of the Philippines, GR number 257401. And here's Stiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
At the Supreme Court this week, the Supreme Court stressed that contract of services or job order workers hired by the Philippine Amusement Gaming Corporation, or PAGCOR, are not government employees under the jurisdiction of the Civil Service Commission. The court, however, reminded PAGCOR and all similar agencies that while their authority to contract services is recognized under civil service rules, such hiring authority should not be used to mistreat or otherwise mismanage contract of services or job order workers. The Supreme Court welcomed the enactment of two laws establishing additional trial courts in the country. Republic Act Numbers 12025 and 12026 created 3 additional regional trial court branches in Muntinlupa City, National Capital Region, and 4 additional RTC branches in Calawag, Quezon Province. From October 15 to 16, the Supreme Court hosted the 2024 Asian Mediation Association Conference at BGC Taguig City. The conference, themed Harmony and Strategic Innovations in Mediation and ADR, gathered global experts and practitioners in mediation and alternative dispute resolution. The 2-day conference featured 8 sessions designed to foster dialogue, inspire discourse, and share insights on various aspects of mediation and alternative dispute resolution. The Supreme Court continued to seek input, suggestions, and feedback from judges, legal practitioners, and members of the academe from Bohol and nearby provinces at the regional consultations for the proposed amendments to the Rules of Criminal Procedure on October 17 and the proposed amendments to the Rules of Civil Procedure on October 18. The regional consultations aim to engage various stakeholders, including judges, legal practitioners, and the academe, in discussing proposed amendments to the Rules of Civil and Criminal Procedure. Finally, the court stressed that statements against public officers do not constitute oral defamation or slander when made in relation to their discharge of official duties, unless these are uttered with actual malice. The court acquitted a woman who issued defamatory statements against a barangay kagawad, as the statements were related to the kagawad's official duties. The prosecution also failed to show actual malice on the part of the accused. And that's your Supreme Court this week. I am Tiffany Doblatran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazan Irania as researcher, EJ Najares, Victoria Daniel, Henry Campo Jr., and Gabby Clint Enriquez as sound editors, and Tyke Flores as web editor.